Good evening, everyone, and a warm welcome to today's webinar on labor codes, driving cost or compliance, organized by the Indo-American Chamber of Commerce. Today's session brings together distinguished leaders and industry experts to share practical, real-world insights on the new labor law codes and their implications for employers and employees alike. Our distinguished panel speakers includes Ms. Sonakshi Das, partner J. Sagar Associates, Dr. Augustus Azaria, Chairman HR Committee South ASSOCHAM, Ms. Alpa Sood, Director Legal Marvel India. And I will be your moderator for today's session. Before we begin, I would like to introduce Mr. Chandrakant BN, Regional Vice President IACC and Founder Chairman Payroll Group. Chandra is a career entrepreneur and ICF certified leadership coach who has built and scaled high-impact ventures across IT services, digital operations, manufacturing, and leadership development. As founder and chairman of Payroll Group, he oversees a diverse investment portfolio while actively mentoring CEOs, business leaders, and startups. He's the one who started Theorem India in 2002 and scaled it from a 2-member startup to 1,300 people across 4 continents, including a 5-acre global campus in Mysore. Chandra, I would request you to please deliver the opening remarks.
Thank you, Amrita. Hope you can hear me clearly.
Yes, Chandra.
Right. Okay, great. Thank you, Amrita, for that generous introduction. I think I'm the least important person in this panel today. I think we have some wonderful panelists who are going to talk about the topic which is in discussion today. But on behalf of Indo-American Chamber of Commerce, I welcome all the guests today who are attending the webinar. And I think, the topic itself is of tremendous relevance. We are at a pivotal moment in India's labor governance policy. It is being touted as it's one of the most sweeping labor law overhaul since independence. The government has consolidated 29 older laws into 4 labor codes. And so what does this really mean to us? How does it impact us as in business people, as employees? So I think it's going to be a very interesting discussion today and a very relevant one. From an employee perspective, I think a lot of people who got left out in the past will probably get included in this. And then from a business perspective and SME perspective, I think this is going to increase the costs of compliance and in terms of meeting statutory requirements, etc. So that's why the question as are the new labor codes a compliance burden, adding cost, complexity, and uncertainty, or are they a reform, a modernizing reform that yields long-term benefits for both workers and industry? I think over the next hour or so, we are going to unpack this, binary and figure out what is it that it's going to yield in terms of benefits for both workers and industry. So I'm as much as all of you, I'm looking forward to this panel and the discussion. And we have an able panel here who are going to talk about this from a legal perspective and otherwise. So welcome to the panelists. Thank you all for hosting this panel for us and doing what you're doing today for us. On behalf of IACC, I thank you. Thank you, Amrita, for moderating this panel, and Jerry, the chairman of Karnataka, great idea, Jerry, and thank you for sort of conceptualizing it and creating this webinar, which is at a very apt moment. And welcome to all the people dialed in and looking forward to this session. Thank you very much.
Thank you, Chandra, for setting the context for today's discussion. What you've mentioned is actually very, very vital. And yes, we have to consider this point because this is something that we all are looking at and working towards. Getting started now, as we all know, over the past few weeks, there's been a lot of dialogue, debate, and even confusion around the new labor codes into four comprehensive new labor codes, in the recent notification. The new codes consolidate and replace 29 existing central labor laws into four comprehensive, modern, and simplified codes. These changes bring with them both opportunities and, of course, challenges, from compliance requirement and cost implications for employers to enhanced benefits and entitlements for employees. So before I start with my Q&A or I start with the panel discussion, I would like to bring in our first panelist, Ms. Sonakshi Das, who is a key member of the firm's labor and law employment practice. Over the years, she has advised clients on all aspects of employment law, from compliance and benefits to policies, terminations, and large-scale workforce restructuring. She frequently represents multinational companies on policy frameworks and disciplinary procedures. Sonakshi was featured in BW Legal's Top 30 Lawyers in India Under 30 2024 and is widely published on employment law topics. Well, Sonakshi, with such a background, I'm sure you will be able to answer the question that I have for you this evening. So, Sonakshi, my first question is, what do the labor codes actually stipulate in terms of costs and compliances for organizations that has become the subject matter of so many discussions across our country?
Thank you so much for the introduction, Amrita. I hope I'm audible. Okay, thank you so much. Before I take up this question, I would like to sincerely thank IACC for having me here on the panel today, and also to each of the participants who have joined us. And I really hope at the end of the session, we're able to address some of the running concerns around costs and compliances under the labor codes. So now, coming back to your question, Amrita, as you rightly said, the labor codes have consolidated 29 central laws into 4 unique and streamlined codes. We have the Code of Wages, the Social Security Code, the Industrial Relations Code, and the Occupational Safety and Health Conditions Code, right? Now, when we speak of costs and compliances, let me break it down into a couple of subsets. First, let us talk about costs. Now, costs under the labor codes can be broadly divided into organizational costs and employee costs. To an extent, these two subsets can be interlinked to each other. So I will explain what some of the new implementation under the labor codes are, which can collectively increase costs for an employer, right? So first, let us talk about wages definition under the labor codes. Now, we all know that the labor codes have unified the definition of wages across the codes. And contrary to the wildfire information spreading across media that basic salary must be 50% of CTC or that allowances cannot exceed beyond 50% of the CTC, what the codes actually prescribe is that in case compensation structures are framed in a manner where the excluded components from the definition of wages exceeds 50% of the total monthly salary, the exceeding amount will be deemed to be wages for the purposes of calculating benefits under the codes. So for organizations who have framed the compensation structure in a manner such that the allowances and other components which are excluded from the wage definition, they exceed 50% of the total monthly salary, it could have a cost impact on them while determining social security benefits, because then the calculations will now have to be done in a higher component. Now, second thing, let us talk about what do the codes now require of fixed term arrangements. Now, across India, particularly states like Karnataka, with heavy engagement in the IT/ITES sectors, it is a very common practice to engage individuals on a fixed term contract basis, either linked to small scale projects to fill in interim gaps when employees move on maternity breaks, sabbaticals, and for related reasons. Now, with time, there was an increasing concern around the fact that these engagements were in fact sham, where employers engaged fixed-term workers with the intent to deprive them of certain benefits available to regular employees. So now, recognizing this gap, the codes have mandated employers to provide fixed-term employees with all benefits available to regular employees under law, irrespective of the tenure of their engagement. And second, fixed-term employees are now eligible to gratuity after they finish a service period of 1 year. So for organizations relying heavily on such engagements, or where the need to engage fixed-term employees has been historically critical, this requirement could ultimately enhance cost factors at the time of contract expiry, right? Thirdly, now let us take a look at what the codes require aggregators to do when it comes to social security for gig and platform workers. Now, who is an aggregator? An aggregator is a digital intermediary or a marketplace for a buyer or user of a service to connect with a seller. Now, so for instance, like we all know, all app regulators like Uber, Swiggy, Zomato, all of them are likely to be classified as aggregators under the Social Security Code. Now, what the code requires is for these aggregators to deposit 1 to 2% of the annual turnover into central and state government funds, which are yet to be implemented as on date, for the welfare of these workers. So now these contributions are capped at 5% of the total amount payable to the gig and platform workers. So, of course, while the intent and the spirit of the law here is to recognize and provide social security to the unorganized sector, by default, this is likely to increase costs on employers, right? Another area which is very likely to enhance costs for employers could be exits, particularly when it comes to retrenchments. Now, retrenchment is basically any form of a termination by an employer for reasons other than conduct or in case of contract expiry. Now, the codes require employers to deposit an amount in a worker reskilling fund, in addition to paying retrenchment compensation to these workers. So, when organizations conduct downsizing exercises, which is so common in the Indian market, for instance, in case of redundancies, position eliminations, restructuring, added costs burdens are going to be very likely, right? So, these are essentially some of the key areas where employers can certainly expect an enhanced cost outflow when it comes to the labor codes. Now, to answer the second part of your question on compliances, and I'm mindful of the time limitations here, the way I see it, the codes have tried to draw a balance between employer obligation linked compliances and organizational compliances, right? When it concerns employer obligation linked compliances, there are several additional guardrails introduced through the labor codes. But when it concerns organizational compliances, the codes have certainly streamlined them in a very significant manner. Now, take for example registrations under the codes, where companies will now be required to apply only for a single registration, as opposed to separate registrations under each statute, which was the case earlier. And where companies are, as on date, already registered under a central law, that registration will continue to exist until it expires, and that will be deemed to be a registration under the codes. So, yeah. So, with that, I hope I've answered like a very broad-based input.
Absolutely.
Yeah.
Now, that was very helpful, Sonakshi, and that actually sets the next question for me, which I'm going to ask Alpa. But before I ask, I think people should know who Alpa is. So Alpa Sood is the Director Legal at Marvel India. She leads the India's legal strategy with a strong focus on employment law, commercial contracts, and litigations and government affairs. Trust me, you all have got very heavy words in your profile. With experience at leading organizations like Honeywell and Emerson, she brings a wealth of insight into corporate governance, compliance, and policy. She actively participates in industry discussions on data privacy and AI and holds a law degree from ILS Law College, Pune. So, Alpa, my next question is to you, following up on Sonakshi's question, that how do you think companies in your peer circles are approaching the new compliance requirements under the labor codes? And I'll add on to that question, have any companies initiated implementation measures soon after the notification, or were they already kind of prepared, anticipating that, okay, this is coming? So what are your views on that?
Thank you so much. Again, just like Sonakshi, I'm very grateful that I could participate with this bunch, and it's a fantastic experience. I think Sonakshi started with summarizing everything that I had to at least learn from this panel. So thank you. And just going back to your question, Amrita, is the implementation already done? Where are we on that path? I think as an industry and my peer group, I would say the answer is yes and no. The SMEs, the small, medium enterprises especially, have to do the heavy lifting, where there are multiple bumps for them to implement the law verbatim. Because as Sonakshi pointed out, there are multiple areas where costs are going to be way heavier. For example, the HRA cannot be part of the minimum wages, the applicability of what is the salary in question, 50% of the wages, and other things that, go into the component of a particular salary, which actually becomes a motivation for the employee. Those have been now dictated by the law. Again, fixed employment related gratuity, which adds up. Those aspects make it all the more cumbersome for small, medium enterprises. But the larger organizations have taken a bird's eye view, and they have started to see what is it that they can start with. Are they going to look into the ops cost of it, where I'm talking about CHROs and others who have to look into resources, making makeshift arrangements to see get everything re-audited, implemented, compliance mechanism to be put in place for these new codes? Or are we going to look at what were we trying to achieve with it? Because this first part of your question, is what is it that the organizations are looking at? I think right now they're more focused on what the state rules are going to say, because there's a lot of clarity that still needs to come from those state rules. And the expectation is, given what we thought the labor code would be, and the 65% of our India population, which is Gen Z, Gen Alpha, and others, that relies heavily on flexibility, relies heavily and is driven on compensation, which is not a very long term. I don't think they think about what my retirement is going to be. It is for them now. What is it? Because I would rather innovate now, especially from a tech industry standpoint. I'd rather innovate now, get that for myself, the bank that I want to create, and I go on to the next thing to create. That's the mindset that we're dealing with, and we're going to deal with. Since this comes at a very pivotal time, where we're in the middle of that journey, where the alphas are going to come into the workforce, Gen Zs are now entering the workforce, I think it is very critical to look at a more data-backed approach and look at what influences this particular generation, and which is going to be our economy, which is going to be our base bank. Again, the second point that I think, which is very critical for this generation, was going, I could work with multiple employers or just work part-time with you, and I do my thing half the time. Now, that contingent worker definition in itself, when they try to define the core services, I think the missing part is that there is no definition, which leaves it, again, very arbitrary big gap, where the authorities and can walk in and enforce something that is still not in black and white. That's where I think majority of my peer group is looking at that more consolidated, more forward-looking approach of what it is going to be under the state rules that benefits this upcoming.
So, Alpa, do you think that with the new compliance requirement, which is now to release wages within 2 or 3 working days of an employee's exit, how feasible it would be, operationally for companies to handle this kind of a situation?
I think hit it at the right point. That 2-day period has been a bottleneck for everybody. All of us are trying to understand what does it mean and how we're going to implement it. And again, if you ask me, as even as a non-accounting person, the gap in the errors and what we are trying to identify from an accounting standpoint, how are we going to do all of this? Because there are multiple controls that are there in multinationals, that we have to checks and balances that every transaction in and out has to go through before it actually goes to the employee. If you ask me personally, I'm so bad at math, which is not a good thing. But for me as an employee to go back and check, have I got the right thing, or, has the company committed a mistake? I don't think that's what I want in my payslip, that additional check that I burden on me as an employee also. Forget the organization, which again is going through that checks and balances again already, that aspect.
So, following up with this on to Sonakshi, we did come across a media quotation from you earlier, when you mentioned that not all components of a full and final settlement need to be paid within a 2-day timeline. So how is that? And Can you share, some of your views and thoughts on that?
Sure, sure. Um, really agree with what Alpa just said, right? Like administratively, of course, this is going to pose a huge challenge for organizations. Now, historically, like as abundant market practice, what majority of the companies used to do is that you arrive at a full and final settlement figure, right, at the time of an employee's exit. And even though many statutes that were in place earlier prescribed different timelines, the predominant practice was that as part of the next payroll cycle, at least before that, you ensure that the employees are paid the 45 their full and final dues. This could differ like 30 days to 45 days. It was standard market practice, and we did not see a lot of resistance from employees, because at some point there was acceptance of the fact that FNF is going to come after a period of time, right? FNF is also historically linked to multiple conditionalities, right? The employees need to return company assets, exit formalities will have to be completed, because especially in remote or hybrid working situations, what we saw employers face as an issue is that asset handover used to become an issue, right? Most often employees will not be returning employee assets. So employer wanted to have that leverage with the employees, that you fulfill all the exit formalities in place, and thereafter we'll release these dues. But coming back to a more specific point in your question, yes, that is true. When you look at the definition of wages and what, because I'm a lawyer, I'm going to go slightly technical here right now. You look at the definition under the wage code of the term wages and what the law actually requires, right? It says that every employer needs to pay the employees wages that are due to them in the case of a resignation, termination, retrenchment, or dismissal within 2 working days, right? Now, wages here needs to be read as per the definition of wages under the wage code, which effectively provides some inclusive definition components, and it excludes a lot of components, right? Your basic pay, DA, retaining allowances are all included, and bunch of other components, right? Discretionary bonus, conveyance allowance, gratuity, overtime, all these are excluded components. So one view here could be that all the components of an employee's FNF that is likely to qualify as wages under the code must necessarily be paid within 2 working days. And there are other provisions under the code which regulate the payments of other components, say, for instance, gratuity, right? So in those instances, the respective timelines for payout of these components can be made at their respective intervals. Now, the central rules on this, on the wage code, are yet to be notified. But under the draft rules, gratuity again needs to be paid within 30 days of it becoming due to the employee. So, which is a position which is similarly there under erstwhile laws under the Payment of Gratuity Act as well, right? So, as an immediate measure, employers will need to certainly realign internally to ensure that all the computations and exit link conditionalities are initiated prior to the effective last date of service, so that these timelines can be accomplished. But of course, there remains practical implementation challenges, like Alpa was putting it across so swiftly over there. Say, for instance, like we discussed, return of company assets, whether anyone is working remotely or not, or they have any other contingencies. So, yeah, that's my input there on the question.
A lot of things has to be taken into consideration before this FNF 2 days or 30 days has to be considered. And also, fine, that's interesting to know. So now I'm sure my third speaker must be wondering that when he's going to get a chance. So coming to you, Dr. Augustus Azaria, he is the chairman HR committee of Southern Region ASSOCHAM. He comes with over 2.5 decades of experience in human resource. Currently, he's serving as the regional HR director for APAC, Middle East, and Africa at Kyndryl, an IBM spinoff. He has been instrumental in shaping labor policy reforms, contributing to the Unified Labor Code with white paper presented to the Government of India in 2008. He is recognized globally as a thought leader in people strategy, digital transformation of HR, and public policy. So, well, Dr. Azaria goes by his name as Augie, so I'm going to refer you like that, Augie. So, Augie, I have 2 questions for you based on the inputs that we got from Alpa and from Sonakshi. First, do you see companies looking at these compliance elements as a welcome change particularly considering that some of the licenses and registration requirements that Sonakshi discussed earlier are now condensed and unified? And my second question would be, how do you think that this will or can impact contract labor engagement specifically? Because we are hearing a lot on the contract engagement on this, that it's going to impact in a different way. So from an HR perspective, how do you think integration within companies would be of relevance? Or are there any dependencies on other teams for ensuring, any kind of accuracy in the implementation of these?
So, Amrita, very relevant questions. Thank you very much for having me here, and truly delighted to be here alongside you, Sonakshi and Alpa. Thank you, Chandra, for those kind opening remarks, and Jerry and JSA. Thank you again for having me here. I see that I have friends, colleagues, as well as students who have joined us. So that kind of tells us that this is a topic on our lips every day. Okay. So with that, you said those kind words, and one of them was the white paper. For those of you who came into the workforce recently, the Indian IT services sector started growing in the mid 90s and then started accelerating in the 2000s. And I was doing a role then in IBM as the TA head and various other HR functions. And one of the things that was foxing me was that we were force-fitted into a set of labor laws that were authored many decades ago, some of them even pre-independence, and they were more targeted at the manufacturing and industrial sectors. And here is the boom in the IT services sector, or what you would call the IT export business at that point in time. This is before the GCCs that we have here, all right? Then it was only delivery services. So a lot of things were difficult for us to operate on. And though I don't have a labor law background, I thought that from a HR standpoint, we need to have some ease of doing business. So sat down to write a white paper and called it Unified Labor Codes, based on the knowledge that I had, some of it borrowed from Europe and some of it borrowed from other countries, which at that point in time had some good practices. However, in the discussion that we had with the government, we were welcome, and the government said this is good. And when we asked them, give us a separate law or a separate code for the IT sector or the knowledge worker, the answer was no, we can't do it. But you have the Shops and Commercial Establishments Act, under which you have to, that you're governed under. So we said, fine. And the government was very, in that sense, charitable by telling us, whatever challenges you have, you come back to us, and we will try to, simplify that. So we came with a kind of a laundry list, and one of the first things there was some of the acts that decriminalized, that we wanted decriminalized. And I remember the Apprentice Act non-compliance was, prosecution of employer. And then we said, we need you to change this. And the government reviewed that, and they said, what we could do is we could pass an executive order. And at that point in time, an executive order was passed later on in the mid to late 2012, I think. And that's where the labor code changes actually started. And then the government realized that unless we make this easy for our businesses, then there's no growth. So ease of doing business was definitely one of the drivers, and we desperately needed foreign direct investment. Okay. So with that, the market opened up. Okay. And we continued to live, with this repair system. Something bothers us, run to the secretary, run to the government, as an industry body or as a large employer, and get things done. Now, coming to your second question, is the industry, accepting this? What is the industry response? I think by and large, we asked for it, and now we've got it. And now that we've got it, we've got to follow it, we've got to comply with it. And we have a few more days before we go and discuss with the government on what are the changes that we would like to recommend and propose. Then comes the fact about these whole Gazette notifications. I'm reading literally every day, and I have a different interpretation, I must say. And Sunakshi and Alpa, I might come to you, for some of that clarity, because every time you read the codes, and you overlay it with your process or your practice or your policy, it throws up some other challenge. And right now I have a template that I overlay, and I'm happy to say that I'm able to see, okay, from here to where can I go? Fine. We now got the Gazette notification. Now the next step is to take it down into the ground and see how to make it work. Now, how do we make it work? Okay. One of the things that we are going to make it work is look at firstly our Shops and Commercial Establishments Act. Nothing over there changes for the people out here. Okay. On the contrary, there is a little bit more work. So therefore, the simplification aspect that is so touted about, I don't think is going to cut much ice on that one. Because if you look at it under the Shops Act, you still have to maintain your records and registers. You still have to have licenses. You still have to do so many other things. And the good thing here is that the license Raj is gone. Okay. So which means that there's going to be greater transparency and lower corruption. And therefore, people are able to do transactions with a sense of openness. Okay. So does it simplify it? I don't think so. My personal opinion, I think the level of work and operations as far as compliance goes will continue to be there, and it's going to be slightly more. That is one aspect. And I will take just one case on this, right? If you look at it under, let me take, for example, Code on Occupational Safety and Health. Okay, Contract Labor Act is there. Building and Other Commercial Workers Act is there. That's good for the real estate sector. Okay, then the Interstate Migrant Act is there. Okay, and then under the Interstate Migrant Act, the new code says that every migrant who comes from that state to here, you've got to track them, you've got to have a digital record of them, and then you've also got to pay them every year to go back to their hometown and come. Now, I'm not getting into the costs of it, okay? But this by itself tells you that it's going to be a little bit more expensive, the way these codes have been framed. And then, of course, I will take back my words, based on the rules that are going to be published very shortly, okay? But my first reaction is simplification. We are yet to see them demonstrating simplification. Okay. Now, getting and making them digital and putting them on a Shram Suvidha portal is not about simplification because you have not simplified the forms. Now, for example, even if you take the code under, let me look at one of them. This is, I think, called Form 8. Okay. So what it asks us to do is, it is one form, but I think there are about 8 sheets in that. Okay. And each sheet you've got to fill out under each of those codes. Okay. So you can well imagine the amount of time an administrative assistant is going to be doing that. Okay, we've got AI, we've got various other things to grab that data, and then we can populate sheets. But what we actually want is the self-certification. Allow us to self-certify us, give us the freedom, and then let us operate in a system of trust. So with that, I'm going to pause here. And if you have any additional questions, on the contract labor. So
Yes.
that's a pretty big subject, okay? And so if you look at it together, right? Today we have the FTE, then you have the contract labor. Now, both of them are supposed to be for seasonal and for any spikes in work, all right? And both of them, we have to understand, is not about cheap labor. Because very clearly the Act 6 state, even before the Code on Wages came, that contract labor is not cheap. You've got to pay similar wages that you're paying any other regular worker, except that this has a start and end date. Okay. So there's a shelf life for you on a FTE and a contractor as against a regular. So let's not look at it as a shortcut or something that is giving us a cheaper labor cost. No. On the contrary, it enables flexibility of workforce. We can deploy them, redeploy them. And FTE is a great thing because, it says any number of renewals you can have. Okay. So there are a lot of things there in the FTE provisions also, and I would encourage people to go and read that up. But if you have any questions, please go and post it, and I'm happy to answer it. With that, thank you very much, Amrita, and I hope I've done justice to your questions.
So, Augie, as you're saying that FTE has many other benefits that's going to be added, just like we get the benefits because we are the we are the employees, and even the same thing is going to be done for the contract laborers, which they have not been getting, because even I was reading a couple of days back where I saw that even they will be enjoying the same benefits as you and me.
Yeah.
But is that going to come into effect very soon, or is there any kind of skepticism going on around it?
I think the skepticism could be kept at sector specific. There are going to be some sectors that are going to be impacted by it, and there are going to be some sectors that are going to embrace this. Okay, so we definitely have two different extremes out here, and I think the act needs to bring them both together. But we shouldn't forget the gig worker. All right, there's a lot for the gig worker, and I think it's a great thing. And as industry, we must support the social security benefits because with 1.4 billion people and with a largely rural and farming community, we need more people to come into businesses. We need more people in industry. Only then your per capita GDP is going to go up. Today, we could be the fourth largest economy in the world, but when you look at per capita, our spending power, our value is very low. We need to increase that value. And one of the ways of doing it is to bring them under social security, give them more money that they can spend and help our economy there. Thank you.
Thanks, Augie, for that. So, Sonakshi, coming back to you, we're hearing news that, after the labor codes have been notified, there is an ongoing transition period for implementation. So, what is this transition period, and how should companies approach this period, to ensure that they are not foul of the law?
Right. So, to an extent, that is correct, Amrita. Given the sudden nature in which the four codes were notified, right? It's been a while. The discussion started, even though the first labor code got the assent in 2019, the discussion started way before that as well. So, consolidation of these laws, which took so many years to be framed, to without any notice notified suddenly, obviously took the entire country by surprise, right?
Yeah.
Now, as Alpa and Augie, both of them have summarized it so well that there is the intent and spirit of the law which is there under the codes, and there is a gap now in terms of how you would want to implement that in reality, right? So that gap exists.
Right.
Now, the way I see it and the way I interpret it and the way I have, based on readings that I have been doing, authorities may not be looking at immediate punitive actions for employers during this period following immediate notification of the labor codes, right? Most importantly, there are very critical implementation dependencies on both the central government and the state government in rolling out the rules, which would be very critical for organizations to look at when it comes to on-ground practices and implementation measures. And again, the way I see it, this is a very critical phase for companies to examine what from the labor codes currently applies to them and what is likely to apply to them or be required of them to implement once the central and state rules are in full force in effect. Now, of course, many provisions of the codes do not have any dependency on either the central laws or the state rules, right? So employers must be cautious of those specific aspects, as it is very likely that the expectation is for immediate implementation of those provisions. That said, like I mentioned some time back as well, it's unlikely that employers will be penalized for infractions during this transition come implementation phase. And you take a look at how these codes have now revamped the role of, like, just like Augie said, from inspectors to those of a facilitator, right? So the intent here is not to immediately action penalties on companies, but to ensure a facilitation so that they're able to demonstrate compliance with requirements under the codes, right? And to conclude, insofar as inadvertent non-compliances are concerned at the moment, there is a legal principle which goes by the saying ignorantia juris non excusat, right? It basically means that ignorance of the law excuses nobody. So employers should not ideally be taking the liberty of an enhanced implementation stage on account of the current flexibilities that are available, right? So like I mentioned, proactively integrate all the stakeholders concerned in ensuring that the essence and the spirit of the codes are given effect to sooner than later. I think that would be more critical for companies.
I think the all the employers who are present with us in the audience should definitely be making a note of this, that ignorance of law is there's no excuse for anybody. I think that's one of the very, that should become like a, like a tagline for this now. So coming to Alpa, would terminations now come as an added cost for employers? Because, we were talking about the FNF in the beginning when Sonakshi mentioned that, that 2-day and all that. So is it going to become like an additional cost for the employers?
I think the termination costs will begin to impact the moment you look at the change in the salary structures that the law actually requires you at the initiation, the minimum 50% factor that should be the base pay. That goes into the calculation of the termination cost. That will definitely be an added cost for organizations which are not following the 50% rule. There is also the reskilling cost that Sonakshi mentioned. That will be again an added cost, especially for, again, the startup world and the organizations that are not running on high profit margins, but are trying to be at a profitable, are in their profitable journey. So that definitely impacts. But again, as Augie was also referring to how the law is intended and how it is now come into effect, I think the bigger question for me, and I'm still trying to understand myself, is the intent to discourage terminations, or is it to ensure that the employee gets benefited? Because then the compliance requirements on the organization from 100 employee to has now reached to 300 employees that you can terminate, and then you reach out to the authority. So it's that imbalance is where I think that the government is trying to at least strike a balance by saying that, okay, you can forget, me as a policeman and asking you that, okay, 100 people will let go. How are they getting benefited? I think that's something that is very critical to note. And it's very important to ensure that the workforce that is going away has that opportunity to upskill and be back as soon as possible.
That's interesting. So, Augie, I have a little different question for you over here. Based on your experiences and how closely, your involvement is with the Ministry of Labor and Employment, along with the other industries and the associations, are we expecting any kind of guidance from the ministry or clarifications on some of the open points? Because, we are hearing a lot of things that we are waiting on some kind of notification or some of the other information is going to come up. So, anything on the open points specifically that, whatever we've now discussed. And we do hear, that ministry would soon be releasing a handbook or an FAQ of, some kind of guideline for the employers to navigate through some of the confusions. So how much, can we actually rely on this? And is it really accurate that something is going to come out as a clarification, as a handbook, as a guideline for the employers?
Yeah. Yeah, absolutely, Amrita. Thank you. So I think the government is all out, to support the industry to understand and implement also give them a voice to come forward with their objections and recommendations. And the government, the Secretary for Labor recently, Ms. Gurnani, said that they're going to be releasing a handbook on this very shortly. There's also going to be a set of FAQs around this. So I suppose there's going to be a lot of facilitation around this. Now, apart from this, I'm also going to go back to the lawmakers and tell them, cut us all some slack. The last quarter is going to be big for the business, all right? And
Yeah.
we're all running at targets. We live and die quarter and quarter. Okay, so with this coming for implementation in the next quarter, it's going to put a lot of pressure on the business. So I'm also going to seek some help and ask them to cut us some slack. So I hope that answers it. I want to bring one last point, not related to this question, and that's the important point under the IR code, which is the skilling fund. And that, I would say to those employers here, is something that we definitely need to do. Now, apart from what we are doing as skilling, the skilling fund requires us to pay in 15 days of salary at the end of terminating an employee for whatever cause or reason. Now, believe you me, that skills is the future and skills is the new currency. And these are some of the things we should not go and oppose. These are some of the things we should work alongside the government, use our CSR and various other things to enable skilling of our workforce to drive us to that developed country. Thank you.
Right. No, that's actually very interesting, because I hope, as you're saying, that once these FAQs and the handbook is out, let's hope it's out quite soon, and it becomes available for our employers. The early, the better, because as you mentioned that, yes, we live by the quarter, and this being the last quarter of the financial year, it's going to take a lot of turmoil on every employer. So let's hope it works out the way we all are expecting, and it benefits both the employer as well as the employee. Because at the end of the day, if these new labor law codes being comprised into just 4 codes, it should meet all the 29, yet at the same time be beneficial. So before we take on to the questions from our audience, is there any specific point that our panelists would like to add? Like something important, like Augie added on that question. So Alpa, Sonakshi, before we take on to the Q&A, if you would like to add something to it.
My recommendation for all our participants and for whoever I discuss on the labor codes with has always been that stay informed and stay correctly informed, right? There's a lot of information that's going around on social media, news pieces, which talks about what the changes and reforms under the labor codes have been. So my only request to anyone looking at these changes under the codes would be to just read the bare essence of the law itself, right? Not to rely on articles, not to rely on write-ups or posts by whoever people. They may be right, but for you to be sure on what you want to implement, what the compliance measure is, what you as an organization need to do, open the labor codes. They have been drafted in succinct manners, although interpretation is something that is debatable. All us lawyers, HR professionals, all of us, still try and tackle to find the right interpretation of it, but go by the letter of the law as well. And that would help clarify a lot of doubts.
Yeah. Alpa, if you could summarize and if you could share any of something that we've missed out over here.
I think that's what Sonakshi said, and I think you also mentioned there's been a data fatigue, indeed, especially in literally 3 weeks' time. Friday, DPDP rules notified, a week pause, and then Friday comes labor codes into action. So I think that period was like you understand that my bosses will read it because it's Friday night for them. So I think that is already something that all of us try to crack it as much as possible in this short period of time and understand why we wait for the rules. And even for the other, when we actually get the implementation stages, then get into what they actually mean when we start implementing them. So there's no slapstick time period that the government is also looking at that, this is it, you got to do it now. There is definitely, there will be a trial and error. There will be a time that has been provided for us to relook and look at audit our own agencies, organizations that we are in. And the second factor, I think, it's very critical, as I was mentioning, and I'll quickly reiterate, is looking at the future workforce. How are they going to operate? How are they going to be useful? Given the AI-driven workforce that we are going to have, the ones that are going to be very adaptable to the tools, they are going to be much faster. So how are we going to utilize that time of theirs within the parameters and the guardrails that these laws have? Because I understand that we are not going to be changing them on a regular basis. But yes, we are hoping that these rules are going to be more, at least give us an insight on what that will be.
So thank you to all the panelists. And I think we've kept our audience waiting a lot for their questions. So Sonakshi, as you can see, there are a lot of questions. I don't know how many we will be able to answer, but how many ever we are with the time, keeping time in mind. Would you like to start by taking up the questions which are over here?
Yes, sure, Amrita. I'm cognizant of time here, and I'm sure we've kept our participants waiting for this. But overall, see, if there are any very focused and specific, nuanced questions, I would request our participants to reach out to us separately. But broadly, if I may summarize some of the questions which are repetitive in nature, so we can all give you consolidated inputs on that, is I think one of the questions, a couple of questions were in fact around the implementation period and on the penalizing action of it. Like all of us, Augie, Alpa, and I spoke about it a couple of minutes back. No one is looking, the government, the departments are not looking at penalizing employers at present. I think one of the questions was that what is the timeline do we have to comply with it, right? There is no straitjacket answer for that. There is heavy dependency for state rules. There is heavy dependency for clarity from the government itself. So all of us, all stakeholders involved here, be it lawyers, HR professionals, other compliance stakeholders, everyone is trying to navigate through these compliances together as we speak, right? So we do have certain time to implement these, unless, of course, we receive some clarity from the department, from the government. We discussed in depth about the handbook and FAQs, which the ministry is likely to release. So let us give it some time. Let us see how things unfold. And I think that would be a more practical way to look at things right now. Alpa and Augie, if you have anything to add onto this.
Thank you, Sonakshi. Yeah, there is something I wanted to say here, and that is for those of the HR folks and the various others here, you have to read through the bare acts. We could give you some quick fixes. We could give you just a medicine for a headache, but if you need a cure, you need to read through the bare acts. So I would say, take it home. I've done that. Weekend reading, wherever you're going, take a printout of it, read through it. It's not as boring. I'd encourage you to do it. That's one. And what does it enable you to learn? One is it makes you understand that this is inclusive because we have added equality for all genders here. Positive, right? And today is also the World Day, today's India's Day for people with disability. And I think it's right that the government has brought everybody, including the third gender, in terms of driving equity. So that's a good thing. Last one, health. Health checkups are mandatory for those before 40. So for all of us here, I think it's got various things, and especially on health and safety, those are non-negotiable, my friends. Okay, so go and implement those that are on the health and safety front. Yes, the IR code, the wage code, we can always debate about it, but let us also bring brevity in terms of what we want to ask, and is it fair to ask? Is it helping the community that we operate out of? Thank you.
Basically, you're asking them to again go back to the whiteboard, blackboard, and the school notes and everything.
Let's
I
go
I
homework.
can give you one thing. So I can share a template and you can share it with them. So I will probably finalize it in a day or two. And that template where, you overlay it against your existing laws, policies, and so on and so forth. Then it can net you out to what changes you might want to do. Apart from that, you have people like Sonakshi, as well as Jerry from JSA, lawyers, as well as labor law consultants and consulting companies can help you bridge this gap and take on this new labor journey. Thank you.
Now, that would be really helpful if you can share that. So when, I would definitely from IACC, we will share it with all our attendees and with all our, because I think it's going to be very helpful.
Yeah.
That kind of helps, gives them a better idea. Alpa, would you like to add up or to take up any question over here? And there's one question which is coming up on the time, which I think Sonakshi already answered, that, it's...
Yeah. So, in the interest of time, just quickly on 2 points here. Unless Alpa, you would like to go ahead with anything, I'll just quickly take up 2 points here. I think a couple of questions are around fixed-term employee engagements. So just to briefly clarify there, the entire engagement of a fixed-term employee is very different to that of a payroll employee. So these need not be mixed, or organizations should not be confused with each other. For regular payroll employees, gratuity entitlement for 5 years continues to exist as on date. The reduced threshold of 1 year has now been introduced vis-a-vis fixed-term employees only. Fixed-term employees are different from consultants. They are different from payroll employees. They're different from third-party contract vendors. So that is one quick point on law that I wanted to clarify. And I think I will also consolidate a couple of other questions, similar questions that have come up, is vis-a-vis how do employers now read what provision applies to them, given the fact that rules are pending, given the fact that certain sections are yet to be notified. So just my perspective there, and to answer the specific bunch of questions. The EPF Act, certain provisions of the Provident Fund Act are yet to be enacted, which means that they don't form part of the labor codes yet. The current statute remains in force. Another way, just like Augie said, pick up the BEAR Act and read. I think a bare reading of the codes will give you the information on what are the acts that the codes have subsumed and which stand repealed as of now. And there you have your answer that the other statutes existing in place, like say, for example, your Shops and Commercial Establishments Act, your Prevention of Sexual Harassment Acts, all these are standalone statutes which continue to exist, and hence compliance from these statutes would become imperative for organizations. Alpa, would you have anything more to add to that, or Augie?
I think I just found an interesting question, which is more on the, related to where if there's an absconding employee, does the termination still continue to apply? I think these are very situational questions that organizations deal with on a day-to-day basis. And I don't think law is trying to empower anyone, especially not the wrongdoer. And if you are an absconding employee in terms of a definition of the service rules that the company had, I think that is a red flag in itself. So the question that now, should I need to comply or not? I think it's going to be very practical. And as Augie said, friends from JSA and your in-house lawyers will be happy to answer those questions.
Interesting. So
That's it.
thank you, all of you, for all the speakers and the participants. And of course, I think the insights and hearing to all your views from lawyers and from industry experts like Alpa and Augie, of course, it has brought in a lot of clarity, which we were looking at. And I think it has answered most of the questions that when our audience joined with, that what to expect, what not to expect, and when to expect, and how it's going to benefit all of us. I think thank you so much for that. I would request our chairman, Mr. Jaral Manoharan, to, if you can, share your views before we close this session.
Thank you, Amrita. I just want to really thank our speakers today, Augustus, Alpa, and Sonakshi, for sharing some very important and very practical inputs in terms of steering our way through this whole new governance legal structure. I also want to place on record that Indo-American Chamber of Commerce is a very old trade body which tries earnestly in building corridors and vital engagement between the US and the Indian economy. And IACC also works with other trade bodies in the states of US to build new ecosystems within India, whether it's in terms of technology, manufacturing, pharma, textiles. So please look up IACC. It's a vibrant platform to be a part of. And once again, thank you, Amrita, for moderating this session so very nicely. Chandra, thanks to you, and your leadership means a lot to us at IACC. Thank you very much for your opening comments. Once again, thank you, Sonakshi, Alpa, and Augustus. Augie, my friend. Thank you. Bye.
Thank you, everyone, for joining, and to the speakers, to the Vice President and the Chairman, Chandra and Jerry. And yeah, we will share the recording of this session with all of y'all. We'll also share the profiles of our speakers so that, if y'all have any further questions, y'all can always reach out to them directly. Or, of course, IACC is there. We can help you to reach out to them and get to the questions that you're looking to be answered at. So as we said that, it was really an important discussion that we have addressed today. So once again, thank you everyone for being with us, and have a wonderful evening ahead.
Thank you so much, everyone. Thanks.
Thank
Thank
you.
you, Amrita.
you.
Thank you.
Thank you.
Bye.
Bye.
Bye-bye.